All right, let's go ahead and call this meeting to order. The House Energy, Utilities, and Telecommunications Committee. Let's see. Chairman Cantrell, would you open us up with a word of prayer?
Mr. Chair, thank you. Let's pray together. God, this afternoon we recognize again how completely dependent we are upon you, so we ask you to give us wisdom this afternoon as we consider the business of Georgia. Help us to make good decisions that will make life better for all our residents. And so we pray that in Jesus' name. Amen.
Thank you. Let's see, we have two bills here, both by the same author from the Senate, Senator Gooch. Just thought I'd wait just a minute or two. I know we have some people coming that are presenting bills over in the Senate, I guess. Representative Fraser's on her way, I see. All right, Senator Gooch, recognize you if you want to present Senate Bill 17.
Senate Bill 17 is a pretty simple bill. There's 4 telephone co-ops in Georgia that currently do not offer broadband services because Georgia law just doesn't allow them to. This bill authorizes them to do so, somewhat similar to what we did with the EMC bill that you all passed and the Senate has passed as well. So the names of the companies, I can give you those names. They're pretty much all in rural Georgia, down in southeast Georgia and southwest Georgia. So, Mr. Chairman, I'll be happy to answer any questions you may have.
Any questions of the sponsor of the bill? Yes. Yes.
Senator.
Yes, sir.
Let me turn your mic on just a second.
I think you'd
I'll
allow me
sit
to turn my mic on and all.
Well,
Mr. Chairman. Hey, Senator, thanks for bringing the measure.
My pleasure.
Tell me about how these guys getting in this business and their access with the Universal Access Fund was work. Because in the past we've had, is it not true we've had issues with small telcos getting, being in business and charging intrastate connection fees and a whole bunch of things whereby they, got in these various businesses and couldn't make it work, but got subsidized through either the fund or intrastate fees. I mean, these folks not have access to phone service already, or
I'm looking for the line number, but these companies will not qualify for the Universal Access Fund for the deployment of broadband. So this will not allow them to use that money for that purpose, just like the other companies. So
Okay.
it's a parity issue, levels the
Okay.
playing field with every other provider.
that's fine. I'd see that now. It is, I think it's on 48, 46,
Thank
47,
you. Yes, sir,
48.
that's right.
Yeah. Okay.
Yep, you got it, 46, 7, and 8.
Any other questions from members of the committee? Yes, Representative Meeks.
Thank you, Mr. Chairman. Senator, could you, which co-ops does it impact?
Sure, I'd be happy to tell you. Bullitt Telephone Co-op, which is located in Statesboro, serves the majority of Bullitt County. Pineland Telephone Company, located in Metter, Georgia, and they cover about 1,200 square miles in Candler, Emmanuel, Johnson, Washington, and Burke counties. Planters Telephone Cooperative, located in Newington, Georgia, which provides service in Screven and Effingham County. And the last one is Progressive Rural Telephone Cooperative, located in Rents, Georgia, and provides services in Lawrence, Dodge, Wilkinson, Blakely, and Wheeler counties.
Thank you, sir.
You're welcome.
All right. I don't see any further questions. Is there anybody signed up to speak on this? We do, yes. Mr. Wise. If you tell us who you are, we know who you are, but tell us who you are and who you represent.
Wise man.
Mr. Chairman, members of the committee, I'm Adam Wise with the Georgia Telecommunications Associations. We represent 23 rural telephone companies throughout the state of Georgia, including the 4 cooperatives in this bill. We think it's a good measure. and would help continue to provide great service in rural Georgia. And to follow up on Representative Martin's question, the statute for Universal Access Fund currently prohibits funds being used or allocated to broadband deployment. It's only for telephone service, and we tried to cover that in here and just reiterate that this will not be used for broadband deployment as well. And happy to answer any questions the committee may have.
Any questions, Mr. Wise?
Mr. Chairman, just follow that. And I think the senator answered the question. I knew you couldn't use it for the broadband. What I want to make sure is that you have the same information in there for the cross subsidization. You can't use the fund to subsidize the 1FRs and then move that money to broadband.
Correct.
Okay, yeah, I knew you couldn't subsidize directly, but just wanted to confirm the indirect subsidization wasn't all.
Correct. The commission would not allow that.
Thank you.
Any further questions? Chair doesn't see any. Thank you, Mr. Wise.
Thank you, Mr. Chairman.
Appreciate it. We have a motion and a second to do pass. Any discussion? If not, all in favor indicate by saying aye. Aye. Any opposed by saying no? This measure passes. Senate Bill 17, looks like it's LC 363819S. SCS, must be some kind of Senate designation, is approved with a do pass recommendation. Go on to rules. Thank you, Senator.
You're welcome. Thank you all.
But we're not finished with you, right?
No, the best is yet to come.
Okay. All right, Senator Gooch, you recognized to present Senate Bill 66.
Thank you, Mr. Chairman. This bill probably looks very familiar to you. If you were on this committee last year, you had the opportunity to vote for it, I think, twice. And you get another opportunity to do it this year. Hopefully this year we've made the corrections that were necessary to get it to the floor of the House and ask for a unanimous vote. In fact, I think you've already voted for a companion bill that is identical to what you see here before you today. It was House Bill 184, which Representative Harrell carried on your House chamber floor. So this bill strictly deals with public right-of-ways, local cities and counties right-of-ways, to allow the deployment of broadband equipment, small cell technology, also known as 5G. We all have cell phones in our hands or on our bodies operating today on 4G. This technology is necessary in order to go to the next technology, which is being pushed out across our country and around the world, and that's 5G technology. It's 10 times faster than what we currently have. It's going to present us some great opportunities for technology deployment in our areas of our downtowns primarily first, and I think over time you will see it spread out over our entire state. It also authorizes the deployment of air gig, which you've heard some of our friends from the telephone companies talk about, and the utility companies, to be able to get broadband services on power lines. And so I think it's a good move forward. 22 other states, I believe, have already adopted this language, and I hope that we can get this out of this session this year, because there's a great opportunity for hundreds of millions of dollars of investments to come to Georgia from the private sector. The bill deals with a lot of statutory issues and regulatory issues with permitting, streamlining the process. It standardizes the processes to where every city and every county pretty much would adopt pretty similar regulations and ordinances, but they do have home rule embraced in this bill. I would have to say that the cities and the counties have spent hundreds, if not thousands, of hours working with the industry people that are represented here today since last session, almost from the day we left here till this year. They have spent countless hours with way too many attorneys, but they've come to a great compromise, and SB 66 and House Bill 184 represents a great deal of work and compromise. That there were no amendments in the Senate committee, and I hope that we can keep it that way here today. It's identical to what you passed out of the House. And I'll be happy to go into details if necessary.
Thank you. Looks like you want to answer some questions?
Be happy to.
Okay, looks like Representative Stover has a question. Oh, okay, where's that, Martin?
Thanks, Senator. You talked about, I have some specific questions, but can you tell me, the home rule is alive and well. I mean, let me give you an example and ask you this. And I've spoken with some others, so if you need technical things, I'm not trying to, this is not an attempt to trip you up. I just want a serious question.
No problem.
The definitions are, they refer to one another in here. And there's special accommodation for historical district and decorative poles. Decorative
Yes.
poles is, I'm not going to read the definition, you've got it, but it's defined as a number of things, an authority pole. And an authority pole is defined as a number of things, but not an electrical pole.
Mm-hmm.
So I have a situation up in the city I represent. There's a little outfit up there, a nice little development called Avalon. Avalon went in with certain design characteristics and standards, and the light poles out there that were put in there were more than likely put in there by agreement when the property was zoned to be of a certain aesthetic look and feel. But I'm guessing, and I believe I know for a fact, that they're not owned by the developer. They're in the right of way, and they're owned by probably Georgia Power. I don't know if they're here. Georgia Power, one of the EMCs. So they're electrical poles. Therefore, they're not authority poles. Therefore, they're not decorative poles. So my question is, are those covered in this bill, and does the city have the ability to directly impact aesthetic standards that are in place?
Yes, sir. The answer is correct. If you look line 741 through 753, you'll see the historic districts are protected.
This is not a historic district.
I understand, but there is
Okay.
other language as well that deals with any kind of decorative pole requirements, and that's on line 763 through 776. So cities and counties have the final say on any permits that are issued. They being the utility companies, cannot get a permit to put any of these antennas in the public right-of-way without their permits from the local governments. And the provision is in here to make sure that it's non-discriminatory. Any pole requirements would have to be met by these companies as well, or else they would not get their permits.
Okay, if you could, two things. If you could tell me where the authority is to tell them that they have to put decorative poles. But again, the definitions in the bill, a light post owned by the utility is not a decorative pole as defined in this legislation. I don't believe that.
Power poles, by definition of Georgia Power being investment owned, or EMCs or MEAG, are exempt from this bill.
Power poles, electrical transmission poles are, lamp posts are not. Is that not true? That's my question. I'm not trying to be argumentative with you here, but that's, I mean, I can refer you back to specific lines, and if we want to wait, Mr. Chairman, I'm happy to wait I know there's some.
No, you can
technical-
ask your question. Just make it as,
Sure,
concise
but
and
let me-
pointed.
Well, no, I'm just, I understand the gentleman said they can do historical district and decorative poles. Decorative pole means an authority pole that is specifically designed and placed for aesthetic purpose. It says authority pole. An authority pole means a pole owned, managed, or operated by or on behalf of an authority. That's the city. Such terms shall not include pole support structures, electrical transmission lines, structures, or equipment of any type owned by an electrical supplier. So those aren't authority poles. If it's not an authority pole, it can't be a decorative pole. If it's not a decorative pole, it doesn't fall under the lines you gave us, is what I believe. Again, that's the question I'm trying to get answered. It's very important to the people I represent. So that's what, as we get back to your statement that they have home rule, I want to make sure that we cover, because I think you intend to do that. I think the folks from the business community intend to have them do that. And I think that's a fair ask.
Sure, and I'm sure the folks from GMA are in the room. They can come up and testify to what their language spells out in that, because they work very, very hard to make sure that those issues were covered in this bill. And I would be totally surprised if it doesn't. And so I would rather they point out the exact wording that you have concerns over, and I'm sure they can do that. But again, the permit has to be issued by the cities, not by GMA, not by ACCG,
For a new pole.
For any permit, for any application. So nobody in this room can put a 5G antenna anywhere in the public right-of-way without first applying for a permit to do so. They can put new poles in, but there's a provision for that as well. And all of that is covered, and the decorative poles and the special design poles are all covered in this by detail because ACCG and GMA worked hundreds and thousands of hours to make sure that they covered their bases on that.
And again, Senator, I'm not trying to be organized, but there's not, you mentioned specially designed poles. There's no reference to specially designed poles in the bill. It's decorative poles and authority poles. And so I'm happy to wait,
I
Mr.
understand.
Chairman,
Yeah,
on the
let's just-
definition of, but we still have not made clear to me that a decorative pole covers an electrical pole.
Chairman Martin, I think as the sponsor mentioned, perhaps that's a question you need to pose to the
Per-
GMA. so-
Perfectly happy to
And,
wait.
and I'll be looking for that if they come up, but
Yes,
I'll
sir.
be happy to spell it out for you.
Chairman Martin, you said you had some other, I think you had some other questions.
I'll wait for, the technical experts, because I think that was actually
one of Okay.
the light lifting.
Very good. Any other questions from members of the committee? I see a couple here. Representative Jones. There you are.
Thank you, Mr. Chair. Senator Gooch, I'm going to be frank and earnest. This is to trip you up.
Throw me your best shot.
I think you and I both serve in local government.
Yes, sir.
And if anybody know anything about local government, when you and I both chaired local government, the buck stopped with us.
That's right.
We have a clear understanding that we don't want anything that's going to impede or hurt local governments or take away or usurp their authority where it doesn't make sense. So will this bill help you and I back home?
Absolutely.
Thank you,
If
sir.
you want broadband deployment in your cities and counties, you want to vote for this bill.
Thank you, sir.
Thank you, Representative Jones. Representative Frazier.
Mr. Chairman. Thank you, Senator Gooch, for bringing this bill that I have listened to for the last 2 years.
You make a good witness.
And it's been a very stressful process. But I will say to you this. I'm not in the metro area, and I heard your opening statement when you talked about eventually it will get to the rural area. See,
Yes.
that eventually is not concrete for me because I have to go home on Saturday and do a town hall meeting, and I need to know what eventually time frame means. That's why I'm not doing a whole lot of debating about this bill, about the specifics in the city.
Sure.
I need to know when it's going to eventually get to the rural areas. If you can answer that.
Well, let me give you my perspective on it, and the people that are sitting out here who would be the ones writing the check can give you their perspective. I would say in the near future, you could see this technology deployed in small downtown communities. For example, where I live is Dahlonega. We have a very small rural county. I could see this technology being deployed there in the next 12 to 24 months.
Okay.
When the money is available, all the permitting's in place, it takes some time for this bill to go into effect. I see it happening there first. But the good thing about that, Madam Representative, is that all of these antennas have to be backhauled by fiber optic cables. So that's going to require someone to invest money to get fiber optics to these downtown areas. That's something that we don't have in a lot of rural areas today.
Right.
And so that backhaul fiber can be used for a lot of other things as well. So it'll carry a lot of extra capacity on it. So anywhere you see a 5G antenna, you're going to see a 5G connectivity to a fiber optic cable, which will go underground and back to some network somewhere that have to feed that service, whether it be a cable provider or a telephone company there locally or one of the wireless companies. So it's going to be good for all of us. It's going to bring that investment to our small cities as well. If you want to talk about 5-10 miles out into a town where there's a lot of small county roads that are dirt roads, I would say it's going to take years to see that deployment there. But you're still going to have your antennas for your cell phone providers. They're still going to be the 200-foot antennas. But eventually all of that will change over as time and money is available.
Thank you, sir.
Mm-hmm.
Okay, I see no other questions from members of the committee. If I may, Senator Gooch, I wanted to ask you, you had mentioned that the amount of time that's been put in over the last year since the last session into this by the different parties, including you. I know you've had to put in a lot of time into it also, but you mentioned the hours that the local governments have put into it. And come up with this language that, if I'm not mistaken, like you said, this is exactly the same language that we had passed out of the House. And no changes made then, no changes
right.
made as from your bills that came out of the Senate through the committee
Correct.
process or on the floor. Do you reckon that if there were changes made, it would, because of the amount of time that's already been put into this bill at this stage of the session, it might throw a monkey wrench into it?
It would be disastrous, in my opinion, because it would unravel the months of work and the thousands of hours spent by all the parties involved. And so I would tell you that if any of the cities or counties in the state are upset about it, they haven't made it clear to me. ACCG and GMA should come up and tell you their side of it. I think they're going to tell you
We'll
the
ask
same
them to
thing.
do that, yeah.
Yes, sir.
Chairman Martin, did you have another question?
Well, Mr. Chairman, just since you brought it up, I will. Well, I mean, the bill was introduced in the House on Friday. It passed the House the next Thursday. It didn't come through this committee. It went through another committee, I think, with 20 minutes of testimony on a 27-page bill that to date I haven't seen a detailed explanation of what the sections do. I understand you believe in it. I want to believe in it. But for 2.5 hours yesterday talking with a number of people, you know, I'm still not clear, and we're going to get clear later. You know, if a light pole that is that you and I count lowercase d decorative light pole in an overlay district is or is not covered with the bill, and if it is or is not covered by the bill, can a city regulate the aesthetics? So with respect to all of that, I do have a city that has some interest. I have a city that asked many times for a copy of the bill and was not given a copy of the bill, and the bill was not available to them until Friday when it was introduced on February 8th and passed out of the House on the 14th. So all we're trying to do is get questions so that we know how it impacts a community.
Sure.
Appreciate the work, appreciate the opportunity for people to invest, but you know, if we spend a little time communicating with people, we probably wouldn't, you know, be down at the last minute where we cause a disaster for
I
actually getting an answer to the
completely
question.
respect your position, understand, and I think the answers to your questions are in the bill because the language.
Three good lawyers couldn't find them in 2.5 hours yesterday.
The non-discriminatory language is in the bill. If the cities adopt overlay districts, then that applies to every pole in the right-of-way. Current poles are grandfathered in, obviously. We're used
Overlay
to that.
districts aren't contemplated
Okay.
in the bill.
But design
Martin.
standards are, and those decorative pole requirements are required by some cities and counties, would be recognized, or else the permits are not issued, plain and simple. But ask those questions of ACCG and GMA, please.
Representative Holmes, you had a question?
No, I just have a comment. Quick comment. Since Gucci's worked on this a long time, I have worked as hard as I know how to do this. So many people in this room. We have got to move on this time, and I'm hoping that we can approve this quickly and move on.
Holmes. Who is this? Representative Jones, do you have another question?
Yes, Mr. Chair. Mr. Chair, there has been a lot of work put in this, obviously, and at the appropriate time, I'd like to make a motion that it moves on, and then Representative Martin has some legitimate concerns, and I think Senator Gooch wants to address them, but to hold it up now and go back and forth. Can we move forward?
It's not the appropriate time yet, but thank you for saying that. And with that, Senator Gooch, I think if there's anybody that wants to speak on the bill, we'll ask them to come up.
Thank
It appears that Kevin Carton from AT&T. Yes, absolutely. Yes, please do. Please do.
Unity. I'll just bring it over here. You guys want to come on up here? Come on over here.
I'll just be very, very brief. Thank you, Mr. Chairman and members of the committee. Just to reiterate what Senator Gooch said, just to give you some feel for the process we went through to get to this point. Starting in June of last year, we met every other week as a group, the four parties you see in front of you, to try to figure out the differences that we had during last year's session on this very important issue. As is any compromise, it's very, very balanced and it's very, very specific to the language in the bill. It took us until December actually early January, technically, to get to the point where all four parties could agree on the bill. And actually, all four parties you see before you today not only are okay with the bill, but support the bill. And there's a difference between being okay and supporting. One of the things that fails to be mentioned often on this subject is that there was something that happened in September of last year, which is very important. The federal government, the Federal Communications Commission, passed new rules which took effect in January, which set national standards for small cell deployment. So what this bill does is fleshes out those rules and makes it very specific and clear as to what local governments can and cannot do. That was valuable to the local governments and to the carriers so that we minimize conflict and we can get to the point of delivering better services to Georgians. So that's all I will add, and I'll be glad to pass it in either direction that you so wish.
Thank you. Chairman Parsons, members of the committee, Charlotte Davis. I represent the Georgia Municipal Association, and really just want to echo what Kevin, AT&T, and our other partners here have said. We've spent a substantial amount of time working on this legislation to do exactly that, to not only be neutral, but to be supportive of what's in this legislation and thinking that it's the best measure to move forward on the actual deployment of small cells throughout the state and our communities. To even add to some of that context, I think we saw the first small cell bill introduced at the end of 2017, and from that moment on, we have been engaged in the discussion. We've had concerns all along the way, so it is a very big deal for us as local governments to be here at the table in support of this legislation, because it has been such a large, contentious issue to our membership. But I did want to talk a little bit about aesthetics, because I know that it was a huge concern of our cities. It was a huge concern that we continuously talked about last session, and spent a lot of time over in the interim to actually put in language that we feel comfortable about that goes above and beyond what's in the FCC order for aesthetics. And I want to point out some of those parts in this bill. So not only, let's see, the part that Senator Gooch had mentioned about the decorative poles provision, I think that's back, let's see, on page 20, starting at line 695, I believe that's it's page 22. It starts at line 762. So that's the part of our bill that actually recognizes decorative poles, and that's a large thing to have in state legislation, because going back to the FCC order that Kevin mentioned, there is no recognition of decorative poles whatsoever in that order, which means that the federal government would treat your regular utility pole the exact same as our pretty decorative poles that we have all throughout our cities and downtowns. But our bill does address those, so that means that providers coming in do have to match the characteristics of poles that are set as decorative for aesthetic purposes, and really allows us as a local government to have ability to tell them, this is our design standard, this is our aesthetic, please match that when coming into our community. So that was a large thing for us. But in addition to that, going back to page 11, starting at line 374, and this is the part that just addresses the general permitting, but as part of that, when we receive an application at the local level, part of the things that we consider on whether or not we actually grant that permit to the provider are dealing with things like functional capacity, aesthetic, structural integrity, and that's in the subsection 1 there. If you skip down to subsection 2, let's see, it's line 382 to 383. Installations coming in, it says they have to be similar in color, aggregate size, or other aesthetics that have been previously set and permitted by the city. Of course, they have to be reasonable, non-discriminatory, and we can't impose anything on AT&T that we wouldn't Verizon and vice versa. But that gives us a lot of leeway and a lot of protection on aesthetics to make sure that they are matched. And to the specific comment about Avalon, that's not public right-of-way and would not be under this bill at all. So that's important because the right-of-way definition is very tailored in this bill, and it's different than what we see in other parts of the statute. And we purposely did that to make sure that we're narrowing down entry into the right-of-way, and it's specific to small cell.
Good afternoon, Mr. Chairman, members of the committee. Bob Davis from Verizon. Very quickly, echo everything that my partners here said. I just want to restate what Representative Dempsey said. This is very important to get this thing going after basically 2.5, 3 years. So, I'm sorry, Representative Holmes. I apologize. I apologize. To you, thank you. I've had experience in 3 other states, 5 total with small cells. Florida, Tennessee, and North Carolina have passed bills Money's flowing to those states for deployment of 5G. So I think we really need to get going so investment can be made here in Georgia. Thank you.
Thank you. And I see no questions. Senator Gooch, did you have anything you wanted to add? Par for the course. Chairman Harrell, did you have anything? You were you presented the same bill in the House, and you probably will present this bill. So, did you have anything you wanted to add?
The private sector and our local governments as tightly aligned as they are, and I appreciate all the work that they did, and I would ask the committee's favorable consideration.
The chair failed to recognize ACCG. I just thought you guys were kind of going in turn there.
Thank you, Mr. Chairman. I'm Todd Edwards with the Association of County Commissioners of Georgia, representing all 159 of Georgia's counties. It's been a 2-year process. We've had obviously differences in the bills that have come before you. Didn't think they struck the proper balance between the industry's need to access the right-of-way and the local government's management to responsibly control it on behalf of its citizens. We feel after all this time, this balance has been reached. Not everyone got everything they wanted. That's the nature of a compromise. Not everyone's happy, but we're comfortable. We do support the bill. We urge your favorable consideration. Mr. Chairman, members of the committee, thank you.
Thank you, sir. I think Chairman Martin has a question of one of you all.
I do have a question, and I don't know if this is, but to Charlotte, I appreciate you, and certainly the poles inside Avalon are on private property, but the last time I looked, Old Milton Parkway was a state highway and West Side was a city highway, and they have poles out there that are decorative, and those in fact are on public right-of-way. Those were the ones to which I was referring. And then, Mr. Chairman, it looked like you were, fast forward to move ahead on this. If we have no more speakers, I just wonder if we are going to. I just simply want the answers to. Are there more speakers or no? I'm still looking for the answer of does anybody know if those poles that are decorative, lowercase decorative to the city, to the people that pay the bills up there, are covered in the bill or not? Because in the definition, we keep hearing decorative and special. Well, I'm not trying to hold up the proposition, but I think it's important for us to be able to know that. And I've asked you guys for a couple of weeks, and we were on the.
Yes, sir. And each time we've said that, yes, those decorative poles are covered under this bill.
Can you point that out for me,
yes,
please?
Yes, sir. Line 104. So first, that's just the definition of decorative poles. So first, that authority-owned pole, which is specifically designed and placed for aesthetic purposes. So that right there does designate that this is different than a utility pole. It's different than a telecom pole. It's different than an electric city pole, anything. It's one of those on Old Milton Parkway. So having that in there and having those poles already in the ground and already with the ability to co-locate on those. Now, if these folks want to come in and put an additional pole on Old Milton Parkway, they by those other poles being set with that decorative standard will have to match that same decorative standard when entering that section in Old Milton Parkway. I understand that your question, I believe, was, well, what if it's a non-authority-owned pole? To my knowledge, I don't know any non-authority-owned poles that would be set for decorative purposes. I think that all the others would be with a utility purpose or with a telecom purpose.
Well, and I'm not trying to belabor. It's a simple question. Decorative poles, in the line you referred to, says an authority-owned pole. There are decorative poles along Old Milton Parkway, I believe, that are owned by the electric company. Those are not authority-owned poles. Are they covered or are they not?
Well, all investor-owned utility poles, so Georgia Power, those poles are exempt from this. In addition, state right-of-way is, so I think that both of, in that particular case, I think
West Side
none of
Drive
that
is not state right-of-way. I mean, are those poles? I'm just, so is it your representation before the committee, and I'm not trying to, that those poles would be subject to the same aesthetic standards, attachments to those and poles on that would be subject to the same aesthetic standards as if they were uppercase decorative authority poles? Is that what we all, I mean, there's 4 of y'all that agreed on all this.
That
Is that
is
what
all of our
everybody,
collective understanding.
anybody disagree with that? Okay, that's the answer to at least one of the questions.
Okay.
I appreciate it.
All right, Chairman Martin. With that, Representative Jones, you recognize make a motion.
Mr. Chairman, the gentleman signed up to speak.
I didn't see your name, I'm sorry. Okay, I'll tell you what, if you will go to the microphone over here, and if you can make it, and tell us who you are and who you represent.
And members of the committee, Scott Hasty, I'm an assistant city attorney for City of Alpharetta. I can maybe at least give another perspective on some of those issues that were discussed. The way the bill currently reads, a decorative pole is basically an authority pole. So a street light or pedestrian light that has certain aesthetic qualities to it or is placed for specific purposes is only a decorative pole under this bill if it's owned by the city. Again, that definition of decorative pole states that any pole owned by an electric supplier is not a decorative pole, or it's not an authority pole. 95% of the streetlights in the city of Alpharetta are owned by either Georgia Power, predominantly by Georgia Power, but otherwise by Sony or Cobb EMC. 90% of the pedestrian lights, that also applies. So by and large, any decorative pole in the city, unless it's a traffic light, would not fall under this bill in terms of a city's ability to actually regulate the aesthetics of it. The other provision that's pointed out is regulating aesthetics or maintaining a city's ability to regulate aesthetics, which was at line 374 to 377. That doesn't give any sort of general authority for cities to regulate aesthetics under this bill. That section begins, an application shall not be required, basically for a wireless provider to go in and modify an existing small cell. The purpose of this language is basically to go from 4G to 5G without having to go through any sort of aesthetic criteria. They don't have to get a permit for it. It makes it a little bit of a looser process for wireless providers. It just has to substantially comply with what was there before. So there's not even a permit required in order to fall into this section in terms of modifying or replacing a facility. So that doesn't preserve anything to local government. And then kind of the big picture on this is that since last year's proposed legislation and this year's, the FCC did adopt sweeping regulations that preempt state law. And those regulations were specifically adopted in order to provide for the streamlined development of small wireless facilities, broadband, et cetera. And so they addressed many of these issues that were of concern to this body, which was fees. They capped fees. They provided a limited permitting process. And then they established an aesthetic standard that cities have to comply with, or other local governments have to comply with. They didn't preempt local governments from enforcing aesthetic standards altogether. They just basically stated a test that cities have to apply. They have to be reasonable. They have to be objective. They have to be published in advance. So this has to be something that's actually adopted by a city, not just applied ad hoc. And then they have to have some relation. If they're objective, they have to have some relation to what's actually in the right-of-way. So you can't require some pristine structure when you have utility poles with all sorts of lines and other infrastructure on them. So it just makes it a reasonable process, but it still leaves the cities with something to regulate.
Okay, thank you very much. Appreciate it. Appreciate hearing from the city of Alpharetta. We actually have, Representative Jones, did you make a motion? I can't remember. Go right ahead.
Mr. Chairman, I was prepared to move on this, but the gentleman from Verizon, after he mispronounced Ms. Holmes, I'm having second thoughts. Where is he? No, Mr. Chair, I make a motion do pass. Mr. Chair.
Okay, we have a motion do pass. We have a second. Any discussion? Hearing no discussion. All in favor of the measure signify by saying aye. Aye. Any opposed by saying no? No. Senate Bill 66, LC 3821, LC 363821 ERS then with SCS in a parentheses, I don't know what that is, is hereby approved with a due pass recommendation from this committee and is eligible to go on to the Rules Committee. Congratulations. And with that, unless there's something from the committee, we are adjourned.